This is about that automatic vacation of stay, not only in criminal matters but civil matters and across the board.
Yes. Asian resurfacing.
Yes, Asian. I need not place those judgments for the Asian resurfacing because in the interim order, your lordships have elaborated on the contents. And from the reading of the first judgment itself, it appears that that was a case where the only question was whether against an interlocutory order, an appeal could be filed, a revision could be filed, or Article 226, 227 could be entertained. So it's
in the context of PC Act. In the PC,
there was no issue of any civil proceedings arising in that. There was no issue equally what should be done with the interim orders. Of course, it appears that in the course of arguments, the aspect of delay, which nobody can deny that proceedings are getting delayed in the high courts, especially in some high courts like the Allahabad High Court and Patna High Court and so on. And the delays are...
judges also were, that was what was weighing with them, that otherwise, stays just continue for decades to an end, particularly in the larger high courts.
And sometimes the delays are on account of the fact that the accused person will get an interim order and that continues. So they take advantage of it. The trials get frustrated, witnesses, long time lapse, the memories of the witnesses may fade. And in some cases, the respondents, the state is the culprit, they don't file affidavits promptly. And sometimes also, especially in the courts which I mentioned, it is systemic fault.
It's in
fault itself could be for more than one reason, because there are 160 vacant posts in the High Court of Allahabad and only 90 judges.
His filing is enormous.
Filing is enormous. Matters don't get listed sometimes, and sometimes when they're listed, the judges are overloaded with work.
And this is
150 cases.
Allahabad, the problem is magnified.
Yes.
But the same issue, brother, just
Lok was saying in Karnataka, I know that same issue in the larger high courts like Mumbai, and not the fault of judges, or for that matter the litigant, because if there are 200 matters on board every day, 150 matters, 200 matters, and you have to write some reasons, give some order which shows deliberation, application of mind, impossible for the entire board to be completed.
And Allahabad is compounded by the strikes. The lawyers, I have the secretary, Nitin Sharma is here, who is instrumental in filing this. In fact, a very sad episode that happened. And this goes back a long time. Mr. Mishra and this Vittal are aware, but the VC Mishra,
Oh, yes,
10 days.
absolutely.
So for months together, the strikes used to go on and at a drop of hat.
No longer, actually. I don't think after 2000 and.
Chief Justice Todi Lord was the person who,
Despite so many judgments, because I don't know why the lawyers adopt this trade unionism tool.
5 days.
10,000 meters.
So it's not that once a while it happens. It happens quite frequently and regularly.
Dwivedi, what is to be done then? What is the solution? Because if a judge grants a stay in a 482, they virtually
Means that, nothing is going to come up in the next.
look, the
maybe
first
for-
question which perhaps the lordship will have to look into is, do we find a solution, Lord, which is creates
Worse
a
than.
greater problem, which is worse than the disease?
So it results in one more round again.
No, we have to create in every discipline civil revisions, appeals, and tax, and a separate bench which will consider now the extension of same amount of time and the court says in resurfacing, give reasons while extending, which daily means not that both sides have to be heard. It's not like that we not able to take up, then we say extend it till the next date automatically. So, and that can happen in any court, not even in this court it can happen. The matters, for some reason, some important matter is going on, other matters are not taken up. Your lordship normally asks not any extension required, it's extended in the normal course. So the judges are not to be blamed, they are making their best efforts, not in the difficult circumstances.
Granted interim relief after it was argued prima facie, you see.
Yes.
So when it comes up for extension, even if it's another bench, it's a principle of, judicial respect for the fact that even assuming the stay was granted by another bench, it has applied its mind.
Yes.
So the question, that's one important question, or do we come out with some formula, etc., which in this manner results in a vacation of a stay order with application of mind. And what is this formula? It's automatic. Neither the Supreme Court is applying its mind, because this is a kind of a judicial legislation. Automatic vacating
For all cases, for all times. So because of this, this court is not applying its mind to the facts of this case, that particular case, and High Court is also not applying. And in the second resurfacing which followed, this court directs the magistrates that you have to implement this, proceed.
But in some states, there are contempt petitions filed against the honorable judges. Because of the direction that it is the responsibility of the concerned learned judge to proceed. Some litigants, in Punjab, Haryana, in 3 or 4 states, contempt petitions are filed joining the honorable judges by me, the judges who were to conduct trial. So I join my learned friend, the solution perhaps is more severe than the disease. So we need to find out a solution, but this definitely is not the solution.
So I submit that this automatic reservation is no solution, neither practically nor on a legal plane.
what do you have to say about Article 226(3)?
Now, that's what the first question is that Article 226 is a basic feature of the Constitution. If 226(3) is to be applied, then it will have to be tested
Whether that can be done. If Article 226 is part of the basic structure which this court has repeatedly held, not it is. So it cannot be taken away, it cannot be whittled down.
neither by constitutional amendment. This is something like Indira Gandhi's case, where now by constitutional amendment you are deciding that it will get automatically vacated. So who is applying the mind? It's interference with the process of judicial review. So if challenged, it will be liable to be struck down. But the High Courts, in some cases which we have cited, have therefore said that this is direct. They took another route. In Bombay High Court has also taken that view.
Yeah. And
Madras High Court
this provision came in by the 44th amendment.
Yes. So I think that's the best solution, to leave it as directory, my lord. Otherwise, my lord, we will have to amend the petition and question 226(3) as ultra-vires.
368 cannot be used to bring in a provision of this nature. But in a way, my lord, the direction in Asia resurfacing goes much beyond Article 226(3). 226(3) says that upon the making of an application by the other side to vacate, if then it is not decided in 15 days. Here it is not required.
The other side has to just sleep over for 6 months. It get vacated.
Technically, even if it's ex parte, after 6 months, the state would be vacated.
Vacated. In many cases, it has happened. That's why in the second case, this court went ahead logically to direct the magistrates to proceed, implement.
The judgments are there before lordship, my lord. Perhaps, my lord, this may also be, my lord, necessary for lordships to consider in this, my lord, with the constitution bench, whether 226(3) is mandatory or directory, because there are diverse opinions among the various high courts, my lord. Although judgments are also there before lordship by way of a compilation file, I mean. I'll place them.
That will result in widening of the
That's
scope, my
not the
lord.
question.
No, maybe, but that will be a relevant thing also.
Possibly that's not the question, my lord, right now, 226(3).
Then we'll have to come with a petition questioning the validity of 226(3).
No, that's an interpretation of 226(3).
No, mere interpretation. Then we'll like to challenge the validity of.
Why should we go in?
If it is to be interpreted, then it is directory.
Yes. And the high courts have given good reasons, my lord. 2 high courts have given good reasons.
Yeah, but हमेशा solution लाता है, problem create करता है. Sorry.
Provision before the amendment, that is in the footnote to this SCC EBC copy. If you have the red book with you, you have this red one. The earlier provision is in the footnote.
It's very good. It gives all the footnotes.
Mr. Dwivedi can read it from this book. It's at page 186. The earlier provision said that if you have not...
Petition
Yeah,
for the
just read it.
redress of any injury referred to in subclause B or C of clause 1 shall be entertained if any other remedy for such redress, that's alternate remedy, or under law for time being in force.
4 and 5. Now see 4 and 5. 4 and 5.
No interim order shall, whether by way of injunction or stay or in any other manner, shall be made on in any proceedings relating to a petition under clause 1 unless copies of such petition and of all documents in support of plea for such interim order are furnished to the party against whom such petition is filed or proposed to be filed.
Opportunity is given such party to be heard in the, that's fine, my lord.
Now see how 5 was. 5 was very carefully framed.
The High Court may dispense with the requirements of subclauses A, B, or
And
of
make.
clause,
and make
clause
an
4 and make an interim order in writing that it is necessary so to do for preventing any loss being caused to the petitioner, which cannot be adequately compensated in money, but any such interim order shall, if it is not vacated earlier, cease to have effect on the expiry of the period of 14 days from the date on which it is made, unless the said requirements have been complied with before the expiry of that period and High Court has continued the operation of the interim order. So that's
So this will not pose any problem.
Yeah.
The amendment, if your lordship sees, which is now there,
See, this amendment will apply only when internal is granted without
Without
furnishing copy and
furnishing
without hearing.
without it.
So therefore, if there is a notice issued, or in some high court practices to serve state in advance,
Yes,
this will not apply at all.
this will not apply.
If copy is given and notice is served,
Served.
then this will not apply.
Yes.
Hardly significant. We can,
limited
yeah,
cases.
so we can.
We don't need to go into it. Going to 226(3), Lord, in this matter. It operates in a different way on
And
different.
in a very limited
conditions.
cases, it will apply.
Yes.
Because once A and B is complied with, then there is no question of an automatic
In high
vacation.
courts, in both high courts,
I'll tell you, Lord, I would submit before your lordships why it's not necessary. Asia resurfacing essentially concentrates on stay of trials. Stay of trials would arise either in 482 or other jurisdictions.
227.
227, not in 226. But 226, my lord, we would be taking support, my lord, to substantiate other submissions. Just to say, my lord, that first, it's a part of the constitution. Here, it's a judicial continuing mandamus. Second, there is at least a requirement of an aggrieved party applying for vacating the stay. Here,
Automatic, without
person
anything.
who is not vigilant enough and sits for 6 months, he is put to premium by getting the stay against him vacated. He has to do nothing except being negligent, to put it, my lord, a little harshly. So that's the position. So 226 may perhaps not, my lord, require your lordship's attention in this matter.
not the copies are served in advance on the state councils,
Absolutely.
except in private disputes. Otherwise, their state councils are always served. And they have an opportunity of being heard. It's other matter that the state government advocates may not be having instructions, etc. So they get time alerts.
In particular that you would like to add,
Only 2 or 3 things.
No, I have not stated.
all right, we will hear you. All right. Yes. So,
I'll not take more.
how would you like to formulate the submission then, Mr. Dwivedi?
No, I have 7 points.
7 points, all right.
Yes.
Just tell us. 1 second.
The judgments I have mentioned in my written submission, but I will not be
Correct.
taking your lordship through it. The propositions are all well settled and well known to your lords. Lordships. First is that this direction amounts to judicial.
Which is that volume, Mr. Dwivedi, your written submissions?
Separate volume.
Sep-
Separate folder. There's a separate volume.
It's a separate volume. High Court bar.
Yes.
They were allowed to intervene in the High Court.
Correct.
The first submission is that this direction of automatic vacation is laying down of a general norm,
Direction for
automatic vacation of interim order, lays down a general norm, and therefore it is in the nature of judicial legislation. And this court, Lord, does not engage in judicial legislation.
yes.
In the same sex matter, my lord, the lordships have elaborated. I don't need to, my lords. The second submission, my lord, that Article 226 is a part of the basic structure of the Constitution. And it can neither be shut out or nor whittled down either by constitutional amendment or by legislation and ought not to be shut out or whittled down in exercise of powers under Article 141 and 142. This is also because, my lord, the High Court,
This is the third point or the second?
third point,
Third point.
is part of the same point, my
All
lord.
right.
This is because the High Court enjoys a high constitutional status and it's not subordinate, my lord, to the Supreme Court. This also, my lord, has been held in several judgments. So merely because, my lord, there is a problem arising, that doesn't mean that the power of the High Court should be curtailed. And there should be any kind of a general direction that even if you have not applied, even if you have not vacated, we are saying it will stand vacated. And even we will not apply our mind, it will get automatically vacated. So the third point, therefore, is that the automatic vacation is neither hinged on application of mind by the High Court nor by the Supreme Court. An application of mind is the essence of judicial decision making. Without which the decision would be arbitrary. So even though not Article 14, etc., fundamental rights are not available to test the judicial dictums, yet your lordships have consistently observed that arbitrariness in decision making is to be avoided. The fourth point is the arbitrariness and the discriminatory character of this direction arises from the fact that it lumps together all sorts of cases, civil, criminal, tax, irrespective of facticity,
Irrespective.
of the cases, nature of jurisdiction, and determination of fault. If I am delaying, Lord, I having obtained interim order twice, thrice, four, I can understand High Court vacates it. Not by an automatic direction, but High Court vacates it because the next is, Lord, a speedy trial includes early termination of vexatious trial also. And this direction does not reasonably balance the two aspects. Both Section 482 and 226 are available for quashing of FIRs and charge sheets and so, even charges in an appropriate case. So one can understand that the court may be directed to be slow, lords, or to give reasons, or to hear. So these are 3-4 directions which can be and should be rather
introduced so that straight away, or maybe it can also be said that in heinous crimes and serious financial irregularities cases or economic offences, if an interim order is to be given, it should be initially for a short period, as the Lordship says, till the next date of listing, so that an opportunity, effective opportunity is there. Government counsel may not be having instructions, so
that will not prevent the High Court from granting appropriate relief. The relief can vary. Sometimes it can be arrest, sometimes it can be staying the whole proceedings. It all depends upon the circumstances. Because we have also seen that there are cases where matters have been settled up to the Supreme Court and people still will not fight it out by filing FIRs, then they resort to criminal proceedings. Some civil nature disputes. They are all carried only to harass. So if in such cases a direction is given till further orders, all that power is there under 226. So there has to be a proper balancing and some minimal directions alone should be given so that there is a guidance to the court, High Court. Lastly, my lords, this ignores two precedents, my lords. Though in the context of trial, not interim order, that is Amtule's case and Ramchandra Rao. At page 4 of my written submission, in paragraph 4, I have given the paragraphs at the footnote. I will stress only para 82, 83, 86, 93 and 94 of Antule's case, that is 1992, 1 SCC 225.
In your submissions, where is it, you said?
Paragraph 4, I will very briefly state it. Two constitution benches in A.R. Antule's case and P. Ramchandra Rao have, while dealing with the fundamental right to speedy trial under Article 21, held that it is not permissible for this court to fix
time limits for completion of trials. The reason assigned is that delay in trial could happen for a variety of reasons. May I read these two judgments, or I can leave?
No, it's very well settled.
P. Ramchandra Rao, my lord, may be seen only because
Okay.
after Antule's case came 3 judgments of this court, where this court identically as in Asia resurfacing proceeded to say that if trial is not completed in 360 days, then trial will terminate. So the matter went back to P. Ramchandra Rao, and they said that this is judicial legislation.
It's in your convenience compilation?
Yes, it is there. Correct.
1399.
PDF 1399.
My lords will find the reference, the issue which was involved. And towards the middle, your lordship will find Rajdev Sharma 1, 2. All these cases, they said, if not concluded, it will terminate. In paragraph 19, Antule's case is noted, and placitum F, if your lordship comes to placitum F, there are other factors contributing to the delay at the trial. And so all these various reasons for delays are noted, and the court says it's all relative. First is non-availability of the counsel, non-availability of accused, interlocutory proceedings, other systemic delays. In addition, court noted that in certain cases there may be a large number of witnesses. In some offences, by their very nature, the evidence may be lengthy. In Kartar Singh, another constitution bench opined that delay is dependent on the circumstances of each case because reasons for delay will vary, such as one, delay in investigation on account of the widespread ramifications of the crime and is designed network either nationally or internationally, the deliberate absence of witness or witnesses, crowded dockets on the file of the court, etc. So all that is said, and then paragraph 20. Several cases coming to our notice while hearing appeals, petitions and miscellaneous petitions, such as for bail and quashing of proceedings, reveal, apart from inadequate judge strength, other factors contributing to the delay at trial. Generally speaking, these are absence of or delay in upon, again those reasons are mentioned. And then 21, the question is posed, is it at all necessary to have limitation, bars terminating trials and proceedings? Is there no effective mechanism available for achieving the same end? The Criminal Procedure Code as it stands incorporates a few provisions to which resort can be had for protecting the interest of accused and saving him from unreasonable prolixity or laxity at the trial amounting to oppression. Section 309 is then referred to. Your lordships can then leave the rest. Please come to 22. Legislation is that source of law which consists in the declaration of legal rules. Again, this definition of, and then the court holds.
Subject of bail.
Last line at page 1421. Bars of limitation judicially engrafted are no doubt meant to provide a solution to the aforementioned problems, but a solution of this nature gives rise to greater problems like scuttling. A trial without adjudication stultifying access to justice and giving easy exit from the solution, from the portals of justice. Such general remedial measures cannot be said to be apt solutions. For two reasons, we hold that such bars of limitations are uncalled for, impermissible. First, because it tantamounts to impermissible legislation, an activity beyond the power of the Constitution conferred on the judiciary, and secondly, because such bars of limitation fly in the face of law laid down by the Constitution bench in A.R. Antule's case, therefore run counter to the doctrine of precedence. There's a quote from William Wade's Judicial Activism and so on, I can leave it. And then 27.
Describing periods of limitation at the end of which the trial court would be obliged to terminate the proceedings and necessarily grant acquit or discharge the accused, and further, making such directions applicable to all the cases in the present and for the future amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts. Howsoever liberally we may interpret Article 32, 21, 141, 142 of the Constitution, the dividing line is but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacuna and fill the gaps, but they cannot entrench upon the field of legislation properly meant for the legislature. Binding directions can be issued. For enforcing the law, and appropriate directions may issue, including laying down of time limits or chalking out a calendar for proceeding to redeem the injustice done or for taking care of rights violated in a case, in a given case, or set of cases depending on facts brought to the notice of the court. This is permissible for the judiciary to do so, but it may not, like the legislature, enact a provision akin to or on the lines of Chapter 36 of the Code of Criminal Procedure 1973. The other reason why the bars of limitation enacted in Common Cause 2, Rajdev Sharma 1, Rajdev Sharma 2 cannot be sustained is that these decisions, though 2 or 3 judge decisions, run counter to the extent to the dictum of the Constitution bench in Antule's case. Therefore, cannot be said to be good law to the extent they are in breach of the doctrine of precedents. The well-settled principle of precedents which are crystallized into a rule of law. Now that's known, Mullahs. And then they affirm the directions from in para 29.
So it's somewhat similar. These kind of directions are actually judicial legislations, something which even Article 368 will not include within its fold.
Yes.
And there is, Mullahs, apart from these submissions, what happens is in the course of it, Mullah, that by issuing